school, they'll tell you it's contempt to be in the school. So that was like a highly detrimental to my dreams as in the future. So now knowing that we've come to a conclusion and I can go back to my plan of fulfilling my dreams, it means a lot to me. Sometimes I read the comments on social media, I'm like, why do I have to go through all of this? But I guess now it's purely concise that I did not really deserve it at all.
As you can see, I'm very, very, very excited and appreciate the fact that the judge stuck to the course. From beginning, she said that she's going to ensure that it is fast-tracked. She was going to expedite it to make sure that the children wouldn't suffer, and she did just like she said. Secondly is that what we said in the beginning about the violation of the Constitution, all along, that was my position, and I maintained it, that the Constitution was being violated. And that is where she delivered the most powerful presentation today.
When are you sending your children to school?
Well, I have to sit with the whole family and then we decide, because we are expecting that the school will give us a warm welcome when we go there. We're not expecting a situation where we are not properly welcome.
Are you saying that you expect some sort of victimization of the children when they go there, or there will be an unwelcoming environment?
I have been advised by teachers there, I've been advised by students there, I've been advised by so many people in society that we should not send them there anymore. But I don't believe that, because it is their right to be there. And whatever challenges they have to face there, they have to stand up as lions and face these challenges.
So that's the reaction yesterday to the court's decision. Well, that joy has been cut short as the school fights back tonight. It is challenging the court's decision, a situation which will mean further delay admitting the boys to the classroom. But we'll be speaking to the lawyers to get a better understanding of this situation. By head of our health desk and also joint news editor, Fred Smith, joins me in studio. Nothing related to health this evening. But what exactly is that statement from the board of Achimota School saying?
Emefa, it's a very brief statement and it's titled Reaction of Achimota School Governing Board to the High Court Ruling on the Admission of Rastafarian Students. It says, the Governing Board of Achimota School was represented in court yesterday, the 31st of May 2021, and has learned of the outcome of the case brought against it by two persons who had earlier applied to be admitted to the school. The court ruled that the religious rights of the two applicants had been violated by the school management as they sought to enforce the time-tested and well-known rules of the school. The court further directed the school to admit the two applicants. The school board disagrees with the ruling of the court, and the school board has therefore directed its lawyers to appeal against the ruling, and it's signed by chairman of the board of the Achimota School.
Thank you very much, Fred Smith. And that's the statement signed by the board chairman of the Achimota School. So far, the board and the PTA have declined any interview with us so far on this particular issue. But as and when they are able to, we'll speak to them on it. But let's bring in lawyer Martin Pebu on this matter. Let's get some legal education on this. Because yesterday when we spoke to lawyers for the two boys, and then also we heard the boys themselves and the family mention that they were supposed to go to school today. It appears that is not going to happen following this decision by the Board of Governors to appeal that decision. They disagree with the court on this matter. We're grateful for your time, Mr. Martin Pebu, here on Top Story. So first off, this decision to appeal, does it vacate the ruling of the lower court?
Not at all. No. So when there is a decision and the aggrieved party, that's the losing party, decides to appeal, that notice of appeal, so they file a document called notice of appeal. Now that document by itself does not hold the judgment in abeyance. No, far from it. So, but rather, after filing the notice of appeal, the losing party has to file what we call application for stay of execution. Stay of execution. So from its name, you can hazard a guess, meaning that whatever is in the judgment, okay, should not be executed. That should not be carried out. So in simple terms, don't implement the judgment yet until after the appeal. So when the lawyer, the losing party's lawyer files that motion, it's an application, they'll be given a date to go to court. So it will be served on the one who has won. So in this case, Tyron Magai and then his lawyers. So it actually will go to the lawyers. Then they will file what we call affidavit in opposition, and then appear in court on the due date and argue. So the one who is in favor, that the losing party, will try to persuade the judge why the judge should hold the judgment in abeyance. That is to stop the victorious party from executing or implementing the judgment. Okay. Then the victorious party will also persuade the judge as to why they should be allowed to implement. So there are some factors that they use in order not for this to become too technical. Let's say here there are some judges. At the end of it, the judge will decide what to do. But at Emefa, the practice usually, every lawyer will tell you, usually at the first instance, when you take the application to the same judge who ruled against you, you are not likely to succeed. It doesn't happen often. Yes, unless, let's say, if it's for payment of money. So if some money, if the judge has ordered that pay some money, then the losing party goes and says, I need some time to pay. I want to spread it over some period of time and all that. Okay, that one, it has higher chances. But where you go back to the judge and say, look, I will compromise nothing. I want you to totally hold back this your judgment because I'm going on appeal. It's usually taking high threshold to cross. Okay, yeah.
But in this case, at this point, there's no stay of execution. So does it mean that the school ought to admit these boys whilst they also trigger the process of appeal?
Yes, that's what has to happen. But also, there's also this document that technically, before to trigger the school to do the needful, there's a document that has to be served on them. It's called entry of judgment. So though Achimota says they were in court, but technically, before you can hold them to account for failing to implement the judgment, you have to file what we call entry of judgment. So a summary of what you've won. Then you serve it on them and ask them. So inside it, they will be informed that the judge has asked that you allow us to count the children to enroll and everything else that the judge ordered. So it's only after they refuse, then perhaps the children's lawyers will also be looking at content and all that on the facts of this case.
Okay. Well, yesterday after that ruling, though, one key question that came up was how we're going to enforce the order. Because it was directed at the school. So if this order is disobeyed, who can be held for contempt? Is it the headmaster, the board of directors, the board of governors? What exactly then will be the case?
So ordinarily, unless maybe there's something else that I don't understand, it will be the headmaster or headmistress in this case, because she's the one who directly controls who comes in and who doesn't come in. As far as I'm concerned, the board of governors, they don't deal with admissions directly. I think they deal with the bigger policy issues, how many dormitories and all those things, improving the school. But who comes in, who doesn't come in, I think it's the headmistress. And then let's quickly add that if the application is thrown out at the High Court, because the school wants to go to the Court of Appeal, they can repeat it in the Court of Appeal. Yes.
Okay.
And even, yes. So if it's thrown out, you have another bite of the cherry in the Court of Appeal. And even in the extreme cases, you go up to the Supreme Court. But that's more difficult anyway.
Well, but the policy of the law is that the court should not grant orders which will require supervision by the courts. But it appears that in this case, we are getting to a point where this order requires some supervision. No?
No, this is not I don't think this is one of them. This one is just allow the boys to enroll. It doesn't require supervision as much. If you ask me, the supervision one is usually the technical one, like, okay, build a house, manufacture a car, do something that's so technical that the court doesn't have the mechanism and the structure to come and inspect and see that what you are doing is quality. You see, so the typical ones are the ones I've mentioned. Build a car, manufacture some ammunition for these people, build a house, construction. You see, those ones, those are usually the technical ones that will require that the court also has to have the systems to check quality and control and the rest. No.
Okay.
But this one, as far as I understand it, let these boys enroll. It won't require supervision as such.
Well, but aren't there various ways by which the school can conspire to undermine the court's order? Because, for instance, can the teachers all come together and say that even though we would admit them, we will not teach them?
No. It's inconceivable. No. Remember, the teachers are paid to do a job. And in fact, it's very important for us to emphasize at this point that these boys won't be the first dreadlock students who enroll in Achimota. Achimota has a very rich history of having educated children with dreadlocks. So for me, I've always been saying that, look, this judgment rather is strengthening the hands of the headmistress that, look, what they were doing in the past was the right thing. They should just continue on the right path. You know, in life, once in a while, we all slack and fall onto the wrong path. But thankfully, the court has brought them back to the right path, in a very short time. So they should just continue. This is not new at all for Achimota.
Okay, but the ruling also makes room for victimization?
Well, you know, human nature as it is, there is a limit to what a court order can do. But on the fact of this case, as I've said, for me, to the extent that these are not the first children with dreadlocks who enroll in Achimota, this is no big deal. They can do it right. They'll take in these boys and take good care of them, because the law requires that in all matters like this, the best interest of a child must be paramount. And I'm sure it's something that Achimota knows how to do well. So let's give them the benefit of the doubt.
We're grateful. That's Lawyer Martin Pebu there, breaking everything down for us. At least we've heard from the Board of Governors of Achimota School. They disagree with the court's decision. And we're bringing Rasin Krabia and also Bright Apia, who is with Child Rights International. Do we have Bright Apia on the phone? Thank you very much for your time here. So it looks like we've lost Bright Apia there on the phone with Child Rights International. We'll also be hearing from Rasin Krabia, who is father to one of the boys. He was in the studio yesterday together with Magai's father, and they were hopeful that they were going to school today. We're grateful for your time, Rasin Krabia. So what exactly is the status of your child going to school? Because we're told that you was going to have some meetings, and then today you were hopeful that they were going to go to school. Did that happen?
Yes, can you repeat that for me, please?
I'm asking if your boys went to school today.
No, they didn't go to school today.
Well, how is that? Because yesterday in our interaction, you mentioned that you were hopeful that was going to happen today. What's the major setback?
Yes, there was a little bit of stress on the young man in the beginning, so we just let him rest today. So we'll be in school tomorrow.
Well, but have you triggered the processes since that ruling? Because today we are hearing from the Board of Governors that they disagree with the court. They are going to appeal the decision. So,
that's fine. That's fine. That's an option that they have, and they have that right to utilize that option.
But
yeah, and I'm not surprised. I mean, you know, we anticipated that is a possibility, and they would have done that. So it's not surprising.
But have you triggered processes already? Have you been to the school after that ruling?
No, I'm waiting on the lawyers to give us direction.
Did the lawyers say what exactly the direction it is that you're going to give? Because listening to your lawyers yesterday,
I mean, the news just came out yesterday just today that they are going to appeal. So they are meeting to address that issue.
And in the entire interaction, knowing that the Board of Governors have this position in terms of appeal, are you hoping that your boys will still go to the school whilst the whole legal tussle ensues?
Well, I mean, I kept saying to everyone that the child have a right based on the Constitution, and we are not going to let the Constitution, the constitutional rights be violated like that. So, obviously, the child will be going to the school.
Rasin Krabia, we'll leave it here for now. We're grateful.
Thank you very much.
We're grateful for your time. Let's bring in Child Rights International, Bright Apia. We're grateful for your time here on Top Stories. So I'm sure you've been following this legal tussle. Yesterday, there was a decision by the lower court. Today, we are hearing from the Board of Governors of Achimota School. They disagree with the decision of the court, and they've indicated that they've directed their lawyers to appeal against the particular ruling. Initially, your reactions?
Well, It is their right to also file for appeal as to whether they disagree with the judgment. It hold water is another thing altogether. But the right of appeal, it is within their domain to do that. And whatever it is that they want to do, they can still go ahead and do that. But once a ruling has been given, all the things that is required for the fulfillment of that ruling, for me, should continue, and we would ensure that the lawyers for Tyrone would enforce that, and then whatever there is that we need to do to ensure that their fundamental rights are protected, we will still go ahead and do it.
But in all this, from where you stand, how hopeful are you that once these boys, whilst these legal tussle ensues, they will get the proper education as they ought to get?
Of course, as for they getting the proper education, it is the responsibility of the state to guarantee them that right. And the Children's Act put it clearly that the interest of children must be to be of a paramount interest to the state. So whatever step that we need to take to do to ensure that we do that. And this will still exist within the Achimota school. I don't think that the fact that they have the right to appeal means that automatically we are suspending their right to education in Achimota. No, all the procedures will go on. And if the court deems fit to accept whatever injunction that they will put on them, is another issue altogether. Because I remember when we filed the interlocutory injunction, her ladyship rejected it on the basis that she wants to speed up the process so that the children's interest would be paramount in the case, so that she doesn't become prejudicial in the process and all that. And that was also accepted in good faith. So we expect that the children will be accepted in Achimota school. They would enjoy every right that they deserve to enjoy in that environment while the appeal goes on. If the court decides to grant them the injunction pending the ruling of the appeal, then that is also another matter altogether. But so far as we are concerned, the right of these children must be given to them, and we would ensure that that happens.
And you're not harboring any fears of victimization of these children once they go to the school?
Oh, not at all. Achimota is an institution. Achimota is known to be an institution of a great repute. So if we are having a legal battle, we are not enemies. We are just ensuring that the right things are done. So this must speak to the conscience of the school to do what is expected of them, so that every single child would enjoy their right in that environment, irrespective of what has happened. We need to also ensure that these children enjoy their right. And we expect that professionally, Achimota will conduct themselves in that manner as to whether they want to appeal. And, this is related to the governing council or the governing board of the school. There are other administrative staff that must work, and they should continue to deliver whatever it is to the benefit of these children. And then whatever the council, the board want to do in respect to they claiming that they disagree with the court, and for that matter, they want to go for appeal. That one is purely within their domain. I don't think that it has any effect on administrative running if these children are accepted in the school. So we also don't want a situation where Achimota will make the excuse that because they will be going for appeal, they don't want to accept the children in school. That would also be a contempt on the ruling that has been made by her lordship. And I don't think that Achimota school would do that. So we are hoping that things will be done in the right way. And I have spoken to the family of Tyrone, and then even Tyrone, the Magai himself, that look, this is not an ordinary case. There are certain things that you expect, and when it comes, brace yourself for it, and then make sure that you have the focus of you learning. That should be the only thing that should matter to you. What you have done for other children is enough. Now focus on yourself. Don't be distracted by whatever happens to you within that environment, but focus on your learning. And I think that with that attitude, I don't think that anybody can intimidate them in the process.
But in all this, are you surprised at the posturing of Achimota School?
Well, Achimota is a bit surprising because I have taken time to read the history of Achimota. until recently that I personally feel that they have deviated from that core mandate of they recognizing fundamental rights of all people in that environment. You remember a child died in that environment, is still in court, and we are pursuing that. And there are all manner of things that are happening to our children in Achimota School. And we expect that if you are managing a school and your interest is to protect the interests of children in that school, but if you seem to defend the decision of the board, which has no bearing on the rights of children, then I don't see what you are doing in that environment, for that matter, to hold a school in that kind of saying that the school is a prestigious school and all that. If the children are not there, the governing council do not exist, the administrative staff will not exist, and teachers will not exist. So the core mandate of that, all these structures, is to protect and ensure that the best interests of children are always promoted. So if the court, the whole court, took into consideration the interest of the child, for that matter, a case that even after everything, the judge has 6 months to issue her ruling, but within a short period, she gave ruling, then it should tell you that the court took the interest of the children at heart. And that is what we expect that Achimota will do in respect to this particular case. And when they issue the statement, I don't know whether, unless you confirm to me whether the statement that was written was by Achimota School. And if that is the case, then
it's from the board of governors of the school, signed by the chairman of the board.
But if you look at the letter, there's no name. It just says that the board governor of the school. I don't think that we should even give credence to the letter, in my opinion. But even if that is the case, I think that there is no acknowledgement whatsoever about what they need to do in respect to the direction that has been given to the court so far as these two children are concerned. All that they are concerned about is that they disagree with the decision, which is their personal one, but it has nothing to do with their right to appeal the case. So if they want to go ahead and do that, we welcome them. But one of the things too that the court made clear has to do with the powers that have been given to the governing authorities of the school. One, it is the Minister of Education that must form the board of directors, and then it is the duty of Ghana Education Service to hand over to them the rules and regulations that they have to administer on behalf of the children to ensure that there is some kind of uniformity in the school and all that. So they can decide to do what they want to do, but once I'm concerned, the authority of instructing them as to what to do now has been clearly defined by the court. That it lies in the hands of the minister to do so, and it also lies in the hands of Ghana Education Service to establish rules and regulations. So they can go ahead and do whatever they want to do.
Okay.
But in respect to the powers that be to ensure that the rights of children are protected in the school does not lie in the hands of the governing authorities, but it is in the hands of the minister and then the Ghana Education Service. So if Ghana Education Service and then the minister also conform to the conduct of Achimota, then that will raise a big question as to whether the system respects the right of children, and I'm not foreseeing that happening. So.
Okay. We'll leave it here for now. We're grateful for your time. That's Executive Director of Child Rights International, Bright Apia. Ending Top Story for tonight, brought to you by GASM, the nation builder. Vodafone, together we can. Newsnight after this break.